Good morning. Okay, thanks everybody for joining our monthly CoC training. Let's see if I can navigate to my screen. Okay. And of course, this stupid bar is always in my way. Okay. How is it looking to you all? It's sharing in a very dumb way on my end. Are you seeing like partial?
We're seeing presenter view.
I knew it. Okay, let's see.
It's fine on my end.
There we go. Is that better?
Yeah,
Not
there we
present.
go.
Okay. Okay. Thank you. All right. Well, welcome everyone. Again, I'm not Jamie. I'm Shelby Ferguson. I'm the Continuum of Care Administrator at Health, Housing, and Homeless Services, or H3. I am facilitating the beginning of the training on Jamie's behalf. This is our monthly for the month of April CoC training on fair housing. And I will introduce our presenters here in a moment. Just general housekeeping things. Please try to keep yourself on mute. I will be the mute police over here. So if I do hear folks coming off mute who are unintentionally unmuting themselves, I will mute you. No worries. If you do have a question, though, feel free to either use the raise hand function or you can put it in the chat. I'll be monitoring both. And just kind of our standard agreements, please make sure we're respecting our trainers. We have two really great trainers today, and we're also respecting each other and everyone here. Please make and take space as appropriate. So if you're a person who maybe talks a lot, maybe give opportunity for other folks to chime in. And if you're someone who doesn't speak as often and you might have something you want to add, please feel free to chime in. We'd love to hear from everyone. It's kind of the same as sharing the mic. Make sure everybody gets an opportunity to share. And then my screen is in my way again. Definitely acknowledge power and privilege in the room. Want to be mindful of that. Okay, so our CoC trainings, as you know, this is kind of just logistical about the trainings. They are monthly. We provide for homeless service providers, and it really covers information that you all need. Some of it is required by our funder, HUD, or U.S. Department of Housing and Urban Development. I'll try not to use too many acronyms for our providers. They are hosted the second Monday of every month from 10 to noon. And this is required for direct service staff, so like case managers, care coordinators, and we would love to see program managers as well. And like I mentioned, some of the trainings are required by our funder, like Housing First, and others are more ones that we just want to prioritize for you all. So this is one that is a requirement. We make sure we do every single year. And some of our more prioritized trainings, but not necessarily required, are like housing focused case management. Some that are great, but we don't have to have. This is one that we do need to have, and it's very important. Okay, tying this into where this comes from, so if you're curious of why we have to have this training or what pieces of the training are particularly required, we have a nice little notice from HUD. I can link that if you want to do some very light reading. But we also have it in our CoC written standards on page 18. I can link that as well of where we have these trainings and why. And then my usual spiel, of course, attendance is being monitored by myself and other H3 staff. Please make sure that you have your case management staff attend. I know not every single case manager can maybe attend when you have a program to run, but please make sure that at least one case manager is attending, if not a few, depending on your size of your program. And attendance is monitored during your quarterly or monthly check-ins with myself or the CE manager, Mary. And then any folks who maybe are not able to attend, please just feel free to send me a message or give me a call. I'm happy to try to find a different time for you all to take the training. As a reminder, the trainings are recorded and they're posted. So if you're not able to attend, but you could take it later, let me know. We can definitely accommodate. Okay, and then before I pass it over to our trainers, I think we always start off our trainings with some equity questions that we want to consider before diving into the training. So 3 questions we want you to consider for today. Have you noticed inequities in your work on the topic of fair housing? And if you're not sure what fair housing is, you'll hear about it in a second. Have you contributed or interrupted any of these inequities? And what barriers do you feel still exist and how might they be addressed? So these are some things we want you to think about during the training. Um, Feel free to drop comments in the chat related to these. Okay, if I can get to the next slide. Okay, so I am going to pass it over to our trainers, Marissa and Maya from Bay Area Legal Aid. Thank you for being here, and I'll pass it to you. Feel free to tell me when you want next slides.
Great. Hi, everyone. My name is Maya Iani. I am a staff attorney with Bay Area Legal Aid in our Contra Costa office. I'm doing some housing work. Some of you might remember me. I'm seeing some friendly names in the chat, so it's so good to see some of you again. I am back at Bay Legal just for 6 months through August. So I'll just be doing some trainings in the community. I'm working on our new tenants' rights line and continuing to work on some fair housing stuff in the office. And I will pass off to Marisa.
Good morning, everybody. Thanks for being here. My name is Marisa Jimenez, and I am a staff attorney at Bay Area Legal Aid. I'm in the housing unit here in Contra Costa County, and our office is in Richmond. I joined the team last November, and I'm in court and doing trainings such as these, and learning a whole lot from my team and our clients. So delighted to be here today. Thank you.
Great. Will you take us to, thank you. So, today we're going to talk a little bit about tenants' rights and fair housing with a deep focus on fair housing. If you want to take me to the next slide, Shelby. Just taking us through our agenda. We'll talk a little bit about who we are as Bay Legal, and then we're going to jump into the substantive stuff. So we'll talk a little bit about the difference between federal and state fair housing protections, reasonable accommodations, which I'm sure come up a lot in your work, and then some other related topics like source of income discrimination and protection for immigrant tenants. We're gonna do a case study at the end, and we're going to talk a little bit about equity at the beginning as well. So, and before we get to the end, we'll definitely allow some time for Q&A. But of course, if you have questions during the presentation, we definitely want you to drop it in the chat. We'll keep an eye out and answer as we go, and see what makes sense. Okay. So if we can go to the next slide, thank you. So Bay Area Legal Aid is the largest legal services provider in the Bay Area. We provide free legal services to eligible low-income residents in 7 counties, including Alameda, Contra Costa, Marin, Napa, San Francisco, San Mateo, and Santa Clara. And here you can basically just see, what service areas we're providing services in. So predominantly, housing, some tangential immigration. We have a health consumer center, veterans work, DV, economic justice like public benefits, consumer law, and youth justice. And Marisa and I are both in our housing team, and that's predominantly what we're going to be talking about today. Next slide. So I just want to briefly go over client eligibility so that if you're sending clients over to us, you kind of have an idea in the back of your mind what we're going through, what analysis we're going through in determining whether we can take someone on as a client. First of all, they do need to live in one of our service counties, or their legal issue needs to be in the service county. And they do need to be either a US citizen or an eligible immigrant. Here's some examples of eligible immigrants, but this list is much more extensive. And then finally, their gross income does generally need to be under 200% of the federal poverty line. I'm showing you all of this with a big grain of salt. Please do not don't decline to refer someone over or to send someone to call us simply because you think they are not eligible. There are a lot of exceptions and different like funds that we can use to serve different types of people. So if ultimately, if you think someone needs legal assistance, send them over to us, let us do the analysis, and then, we can see if we can go ahead and assist them. Okay. Next slide, thank you. And just talking about ways to access our services. In order to access Bay Legal Services, generally tenants and just folks in general need to go through our legal advice line. So we've had our legal advice line for years. Many of you probably know about it. Folks can call in, and whatever practice area, they can get some questions and answers and possibly get referred for potential further assistance. We have the phone number and the days and hours that we're open here, but I really want to highlight at the bottom our new Contra Costa tenants rights line. So this opened up in January, and it is a fully dedicated line for only Contra Costa tenants. So we're just doing housing calls on that line, but it's just really great because they can basically hop to the top of the queue for specifically CoC calls. And, so if you do have folks facing for housing issues, don't direct them to the general legal advice line, direct them to the Contra Costa tenants rights line. Okay. It's open the same hours as the legal advice line, but we're really excited about it, and we want to see more traffic on it. So definitely spread the word if you can. Okay. All right, so jumping into our substantive topics, we're going to talk about fair housing laws a bit. The Fair Housing Act does cover most housing. There are limited circumstances in which fair housing laws owners are like exempted from the fair housing laws. Those are going to be situations, for example, like an owner occupied building with no more than 4 units, single family houses sold or rented by the owner without the use of an agent, and then some housing operated by like religious organizations and private clubs, things like that. Generally, like with roommate situations or shared housing, the fair housing laws are not going to apply. But for most of the housing that we're thinking of that our clients, our mutual clients are living in, the fair housing laws are going to apply. And so let's talk a little bit about what those look like. So you definitely don't need to memorize everything on this page. This is just kind of here for you to understand the source of the protections that folks are receiving in regards to fair housing. So there are both federal laws and there are both state laws that prohibit discrimination in the housing context. And each of these laws provide for different types of protection. Some of these statutes are broader than others. And for example, state law expands on a lot of those federal protections. And we'll talk about that in a couple of slides. But ultimately, what you need to understand is that the purpose of the fair housing laws is to prevent discrimination in housing by making it illegal to disadvantage someone in renting, buying, or occupying a home. We're going to really be focusing on renting because those are the folks that we're generally serving, tenants. But just so you know, the fair housing laws do apply for the buying process as well. Okay. If we can go to the next slide. So, before we kind of get into the nitty-gritty of what the laws say and how tenants are protected, I did want to talk a little bit about equity in the real world and what different types of fair housing trends we're seeing across the country or across the state rather, over the past few years. And, why is this important? Like, how does this practically impact the folks that we're serving? So the first thing I want to point out is the National Fair Housing Alliance did a fair housing trends report in 2023. This was nationwide. And so they essentially tracked how many fair housing complaints were filed with the federal government across the nation, and what people were filing complaints about. So you can see here about 33,000 complaints were filed in 2022, which was about 6% higher than in 2021. And discrimination based on disability accounted for the majority of complaints filed, and rental related discrimination was the most numerous type of complaint filed. And, you know, there's probably a couple of different reasons for that. First of all, I do want to say 33,000, like that already sounds like a lot. And we already know that's just a small portion of incidents that are occurring each year, right? Housing discrimination is really difficult to spot. It's not always that landlord is saying like, hey, I'm discriminating against you because of your gender, because of your race. I think that we, especially people of color, know that, and other marginalized folks of other marginalized identities understand that discrimination can be a lot more insidious and harder to pinpoint, because folks are good at hiding their biases behind coded language, right? And then also victims of discrimination don't always report what's going on because they are afraid of being evicted. They might have some feelings of powerlessness. And so, that might also lower these numbers. And, the reason we might see discrimination based on disability accounting for the majority of complaints filed is because oftentimes those might be the most easy to identify, particularly because folks are asking for accommodations and those are being outright denied. There's a easier place to say, hey, like I'm literally being discriminated because I'm not receiving the accommodation I need. And then we're really seeing mostly rental related housing discrimination complaints, probably because the rental process is this kind of like distinct, common transaction that's happening regularly. And so it can be a little bit easier to identify as well. Whereas, with selling a house, it can be a little bit harder to identify. So that's kind of like just an overview of like what's happening in the nation, right? Like we're seeing tens of thousands of people facing discrimination. We know it's higher, and we're really seeing those complaints that are manifesting rooted in what is easiest to identify. Okay, next slide.
Here a little bit.
And this is really interesting. It's much more closer home. So the Fair Housing Advocates of Northern California did an audit of 60 housing providers in Marin, Sonoma, and Solano. So they sent out fair housing testers in 2022, I believe, and essentially had folks, they were testing to determine whether Latina women with children were treated less favorably than white non-Latina women with children, right? So you send two people to the same property. Their methodology is they give these folks the same like credit background, same application background. So we can really test whether the provider is discriminating based on these characteristics, okay? And they found a ton of discrimination. They found that over 50% of, almost 60% of the housing providers discriminated on the basis of familial status and or national origin, and about 15% discriminated on the basis of both. So, that's huge. Most of the tests revealed that discrimination showing that the housing providers outright refuse to rent to families with children. And in some of the tests, they actually actively discouraged the Latina tester from renting because she had children, but didn't make those discouraging comments to the white non-Latina tester. And they were willing to make exceptions for the white tester as well. So a ton of discrimination kind of being highlighted, right in our backyard. It was really interesting because the familial status discrimination was, something just popped up on my screen. It says, confirm your speaking language. And it identified me as speaking Arabic. How interesting. Maybe I'm speaking too quickly, which I have a habit of doing. So let me take that as a hint to slow down. They did see a higher rate of familial status discrimination in email tests than phone tests. And so that was really interesting because it seemed the fact that these housing providers were so willing to put illegal comments in email really kind of showed a lack of education more than anything, right? Like generally when folks know that they're discriminating, they do it a little bit, a little bit more subtly over the phone or something. So, what that teaches me is like, okay, maybe we need to do some more familial status education, in the community for our providers. And then let me just go to our next slide. And then I see that there's some questions, but I do want to just get through one more equity analysis. I really wanted to highlight this study because I think that it speaks to why all of this is important. What is the impact of discrimination? And what is the impact of, turning people away at the application stage, in the housing stage, or at the eviction stage as well? In 2018, LA Homeless Services Authority did a report on Black people experiencing homelessness, and they found that Black people disproportionately were accounted for in the homeless population. So although they were only 13% of the general population and 26% of those living in poverty, they accounted for more than 40%. And so, what that tells us is that poverty rates alone are not explaining this overrepresentation. And they linked that overrepresentation to discrimination in the housing process. And they did a couple of listening sessions, and essentially a lot of the providers who I think play similar roles to you all, shared that it was much more difficult for them to find housing for their Black participants, precisely because they were being precluded from housing due to racial discrimination. So, when we don't do our part to enforce fair housing laws and ensure landlords are not discriminating, discrimination has a very direct impact on folks' abilities to have a roof over their head. So this topic is really important. And so I'm really kind of excited to get into the nitty gritty with y'all. Before we do, I do see that we have a question from Matthew.
Hello. I was just curious about the study, on the previous slide. How did they determine if they were being how did they determine if they were being discriminated against?
Yeah, so generally, the way it works is we're comparing a couple of, let me not say we, because I was not part of the study. Generally, what folks do when they're sending testers out is they're having them go in and ask for the exact same housing, and they're giving the exact same background, and they're seeing how they are received and what kind of comments are being made towards the renters, right? So in this case, some of the signs of discrimination were the landlord telling one person, no, you can't live here because you have 3 children, but then having this white tester call within the same hour. Generally, they ask that they call within like the same few hours, and asking for the exact same information and being told, oh, you have 3 children, yeah, you can come. And so that's going to be evidence of discrimination. I'm also happy to, I have links to all the studies, and I'm happy to drop those in the chat at the end of, or at some point in the presentation, so that way y'all can also kind of do a deep dive and look in there as well. Okay.
Thank you.
Of course. And then was there a question in the chat? Did I? Oh, okay. No, I just see Denisha makes a comment. Many times a landlord will demonstrate discrimination toward a tenant by rejecting applications for rental tenancy based on a low credit score, no FICO score, no rental history, and a no pet policy. I love that you bring that up, Denisha. I hope you're pronouncing your name correctly. I think that's a really great point, especially because some of these are legal. like a landlord can reject you based on a low credit score in most situations. There's some new laws and some exceptions to that. And so that's another reason why we want to really keep an eye out for any red flag language that might point to their reasoning being otherwise. And then also, you know, there are ways we can work around rental history and no pet policies and things based on some of the stuff that we'll talk about a little bit later. But thank you for bringing that up. Okay. And then Marisa?
Yes, thank you. All right, so here we are. We've just heard about applicable laws governing fair housing and some extremely powerful statistics on the real life impacts of housing discrimination. So now we're going to get into the details about protected classes. So under federal law, race, color, religion, sex, familial status, national origin, physical disability, and mental disabilities are all protected classes or protected statuses. And in California, we are lucky enough to have all of those federal classes as well as additional specified protections. And that would be marital status, ancestry. I'm going to take a moment here to further define that. We'll share the California definition of sexual orientation. It means heterosexuality, homosexuality, and bisexuality. And gender expression and identity is defined in California Government Code 12926 as meaning sex and includes a person's gender identity and gender expression. Gender expression means a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. Moving on, a source of income, medical condition or genetic information, veteran status, and primary language and or immigration status. Next slide, please. All right, and this slide shows us the entire housing process. What do the fair housing laws cover? So starting from advertising, where there may be advertisements that say no children or married couples only, the application process, as Maya explained to us, that's a tricky thing when different applicants are applying, the screening process, and terms and conditions of a tenancy. So different terms may be included in someone's lease agreement, which may not be included in others. And then hopefully not, but we know it happens, the eviction and sometimes termination process. So those are the actions that we're looking at here. Next slide, please. Oh, thank you. All right. Landlords and housing providers are prohibited from discriminating. And here's some of those specific prohibited conduct. Intentional discrimination. So this means that they're treating a member of a protected class or a person associated with them differently. For example, not renting to a person because he or she has a disability or because of their membership in a protected class. Another type of prohibited conduct is the disparate impact discrimination. And this is discrimination that it's conduct that it's neutral on its face, but results in a discriminatory impact on a protected class. And we will talk more about this. Another type of discrimination is sexual harassment. Oftentimes we think of that in the workplace, but it also is insidious in the housing realm. So a hostile environment would be one where there are unwanted sexual advances. And quid pro quo is a Latin term meaning this for that. An example would be requiring sexual favors for housing, services, or privileges. And then vicarious liability is here. And it's important to know that an owner can be held liable for the acts of sexual harassment of their employees and their agents and other tenants. And we also have discrimination against domestic violence survivors. And for an example, evicting a tenant based on calls for emergency assistance. This can have a disproportionate effect on domestic violence survivors and can have a chilling effect on domestic violence survivors seeking emergency aid or assistance. That would also be an impact of disparate impact. Persons who feel they're being discriminated against, or either intentionally or through disparate impact, or who are experiencing sexual harassment, may file complaint with HUD or the Department of Fair Housing and Employment, or you can refer them to us. And if they are eligible for our services, we can assist them. Next slide, please. Thank you. All right, we have come to our first typo. And I believe this is going to be a poll. So
Yeah, let me try to navigate the poll really quick. One moment.
all right, I'll read slow here. Tom tenant lives in a large apartment complex in Concord. He lives in his apartment with his 3 children. The landlord tells him that while children can live on the premises, the children aren't allowed to be outside in the common area at any time. Can landlord institute this rule? So our options here are A, yes.
1 moment. Okay, I'm ready. You should have the poll up now.
Thank you. So our options here are yes, the landlord has the right to control the common areas. Or B, no, this qualifies as familial status discrimination. Or C, yes, because this is not discrimination based on a protected class. What do people think?
We'll give it another second and then I'm going to end the poll. And yeah, if you're not able to access the poll, if you're on your phone, you can definitely put in the chat. All right, I'm going to end it.
All right, overwhelmingly correct. B is the correct answer. The landlord does not have the right to institute this rule because it does qualify as a familial status discrimination. So having a family, having 3 kids, means that they get to use and enjoy the dwelling in the common areas in the building, just as they are as kids. All right. Next slide, please. Here we go. So getting a little more granular here, we're going to review examples of intentional discrimination. So from landlords or housing providers, this could look like refusing to sell or rent or lend to tenants or prospective buyers, discouraging applications, requiring different rental terms or different rules for people in a protected class, enforcing lease terms or house rules differently, segregating through advertisement, steering, or physical separation. And steering could include encouraging someone to look at a different neighborhood or discouraging someone to look at a certain neighborhood based on their race, religion, or background. Responding, it could look like responding differently to requests for repairs and treating applications differently. So these are all examples of intentional discrimination. Next slide, please.
I see there's a few questions in the chat, and Marisa or Maya, please let me know if we should get to them in a different section, but it sounds related to pets, and I know we get a lot of questions usually about pets related to fair housing. So if you want to address them now, great. If not, we can keep going.
Sure, we can take a few questions.
So it looks like there are a couple questions around, let's see, just about animals in general. Can the landlord put stipulations on pets? Maybe that same scenario, your pet has to be under supervision or it can't be tied up outside. Let's see.
Yeah.
Thanks, Maya.
Oh, sorry. Yeah, I'm seeing there's a lot coming up already for dogs and ESAs and everything. Let me go back to this first question about, can the landlord require parent supervision in the common area? I think that's a good question. Landlords can institute like reasonable requirements, of course, as long as they're not like making the housing inequitable. So there are no like cut and dry rules. I think that, like, for example, if there's a pool on the property, like they're pretty easily going to be able to say like, okay, kids need to have supervision, right? This is a safety issue. So I think that, they'll need to tie it to like a reasonable and required, in order to restrict the right, they need to have they need to do it narrowly and make sure they're not restricting the right unreasonably. Okay. And then in regards for dogs, like, it's not going to be the same thing for animals in general as what we're seeing for familial status. In general, under fair housing, there aren't particular protections for pets. I'm not talking about service animals. I'm not talking about emotional support animals. Just in general, yes, a landlord can say you can't have pets on the property. And then we see the exceptions for disability related need for animal. Okay. So in general, yes, a landlord can say no pets or no pets in the lobby or something, right? As long as there's this exception for this disability related needs. Amanda asks, if you're allowed to have dogs, can the landlord tell you that your dog cannot be outside on the property, even tied up? Again, this is going to be depending, like if we're just talking about dogs in general, right? The landlord can basically make any rule that they want, essentially, that you agree to. If you have a service animal or an ESA and you have a reason to need the animal outside tied up, then that's related to your disability. You can ask for an accommodation and an exception to that rule, but you're going to need to show that there is a disability related need to tie the animal up outside if that's otherwise against the rules. And then finally, someone asks if someone has an ESA, but the landlord insurance doesn't allow for the breed. With an accommodation, like you cannot preclude any particular breeds or anything like that. So whether or not the landlord insurance covers it, if someone has a breed dog that has been approved for them as their emotional support animal, the landlord does need to allow that. Okay, and we're going to talk a little bit more about accommodations in a little bit. So if you have any more questions about ESAs or service dogs, we can revisit it then as well. Okay. All right.
Thanks, Maya. There's one more slide. All right, here we are at the disparate impact. So again, this is where a rule may seem neutral on its face, but it has a discriminatory impact on a protected class. So for example, a policy not to rent to a domestic violence survivor who is evicted for her abuser's domestic violence related activity. So that could have a disparate impact on someone looking for new housing. and has an eviction on their record due to the DV. Or a rule requiring tenants to come to the management office to do an annual recertification that could potentially have a disparate impact on folks who have a physical or mental disability, which doesn't allow them to make it to the office or get into the office. A lease term requiring that rent is paid on the first of the month. An example could be where a person who receives Social Security, SSI, doesn't receive their benefits until the 5th of the month, and it would have a disparate impact on them being able to pay by the 1st of the month. And rejection for bad credit related to abusive partner spending. Again, that could be a bad credit report being rejected for that reason due to that abusive relationship. So those are some examples of disparate impact and contrasting that with intentional discrimination. But disparate impact is discrimination that creates these types of different outcomes for different people. All right, so I think this is a good segue into what Maya is going to discuss next.
Yeah, and before we jump to the next slide, just on this disparate impact on these examples, I noticed in the chat, Laura wrote, when I worked in property management, we were told that we could only hold voucher applications for 7 days, same amount as a regular application, knowing full well it would take longer to process a Section 8 voucher than a regular application. I think that's a great example of disparate impact, right? There's just a rule, you process everyone in 7 days, but we know that's going to have an disproportionate impact on Section 8 voucher holders because they simply cannot be processed within 7 days. We know that's not going to work. So you're de facto saying no Section 8 vouchers by having a policy that makes it so you can't accommodate them. Okay. So thank you for sharing, Laura. And okay, so we are going to talk a little bit about fair housing protections for survivors of domestic violence. So, this relates to our disparate impact discussion because under the fair housing laws, right? So remember those laws we talked about at the beginning, domestic violence survivors are not a separately protected class. However, most survivors are women. So just some statistics, women are 5 to 8 times more likely than men to be victimized by an intimate partner. More than 70% of those who are murdered by their intimate partners are women. 85% of victims of intimate partner violence are women. And among people who rent their home, women are 7.4% times more likely than men to be victims of domestic violence. And so, I bring this up to say, although in private housing, there are not specific protections to say, hey, you cannot, discriminate against someone based on whatever domestic violence. Sometimes we can use the gender as like a proxy for this and show like, hey, although basically this rule is disproportionately impacting women. Okay. So let's go to the next slide. So some examples of policies that can violate fair housing laws. So if you evict or try to terminate someone's like housing choice voucher based on violence against them as a survivor, that could violate fair housing laws because it could be, actually gender discrimination. If an owner has a policy that's based on gender stereotypes, right? So maybe if an owner is renting to a woman with a history of domestic violence, and their reasoning is, I'm going to evict them because they always go back, right? That's a gender stereotype, and could be a violation of fair housing law. And then if you see that a owner is treating women differently than they treat other victims of crime other than DV, that could also be a fair housing violation, right? So in this case, we're saying, what if a landlord evicts a survivor of DV because the abuser broke into her unit and she called the police. But then a week later, another tenant has like a random stranger break in and call the police, and the landlord doesn't evict them, right? We're seeing some uneven application of policy there that might point us to this being a fair housing violation based on gender. Okay. And we can go to the next slide. Oh, interesting. Carmela asks, what if a landlord will only speak to the man of the house? Yeah, I think that's going to probably be some pretty strong discrimination claim right there. They're literally refusing to even interact with their tenant, and that could, you know, ultimately you need to suffer some type of damage as a result, right? If I can't make repair requests because you're only going to talk to the man in the house, if I can't, you know, negotiate my lease, if I can't pay my rent to you because you won't accept it from me, these are all things that, you know, I'm suffering because of your discrimination. So I do think that a landlord refusing to speak to someone based on gender is likely going to be discrimination. There might be some exceptions for you know, religious beliefs or something, like maybe, you know, there's some workarounds, but in general, you know, at first glance, I'm going to see that and I'm going to say, okay, you know, let's look at your rights, because I think there's some fair housing law violations happening there. So now here I am saying, okay, you know, survivors of domestic violence don't have protections under fair housing law and in private housing. You know, I want to be specific. We're talking about the fair housing laws. So in private housing, I'm not saying that survivors don't have any protections. They do have some protections. That's just kind of not what we're talking about today. But, you know, if you do have a DV survivor client who is, you know, struggling with some housing issue related to DV, send them over. They may have some other protections. Okay. Now, VAWA is the Violence Against Women Act. It is intended to encourage survivors who receive housing subsidies to report and seek help for the abuse committed, okay, without having to worry about being evicted or losing their subsidy. So VAWA is specifically to protect folks in subsidized housing, okay? So folks in private housing do not have these same protections, okay? This is going to protect folks who are applying for or living in subsidized housing from being discriminated against because of acts of violence. Really want to highlight, I know it's called the Violence Against Women Act, but it's going to apply to all types of folks, regardless of gender identity or sexual orientation. It is not precluded only to women. But again, it does only apply to federal housing programs, okay? So let's go to the next slide and talk a little bit about what VAWA covers. First of all, it's going to cover anyone who is experiencing, is a victim or survivor of any of these things: domestic violence, dating violence, sexual assault, stalking, and it's also going to protect the affiliated individuals of the survivor. So immediate family or any individual living in the household. I'm not going to go through and read these definitions. You'll get the slides and you can take a look after that, but just want to give you a general idea that VAWA does have some broad coverage, okay? And I want to talk about where it applies. So it's going to apply throughout the entire housing process from the beginning to the end. So application to eviction, at any point during this, the tenant is protected by VAWA. So on the application and admissions end, folks cannot be denied housing based on the fact that they've been a victim of domestic violence, dating violence, sexual assault, or stalking. And then on the other end of things, the housing authority, the landlord, the owner, they cannot evict a tenant on the basis of the fact that they're a survivor. And they can't be evicted based on a crime against the survivor that is directly related to the abuse, okay? And generally, in order to terminate someone's Section 8 voucher, the housing authority needs to show that the person has committed some type of serious or repeated lease violation, or they need to show good cause to evict. And there we go, yeah. And you know, in this case, we're saying an incident of DV does not fall under that. Okay, so if someone has been threatened, the landlord can't say, hey, you know, there's too much violence going on here against you, so I'm gonna evict you, right? Like they cannot say that. Okay. So I want to talk about some examples in which they can still evict. So we are going to go to the next slide. So although the landlord cannot evict, generally, if someone is, you know, experiencing harm, they can, if they can show that there is an actual and imminent threat to other tenants or employees at the property if the survivor is not evicted. Actual and imminent threat is going to be on a case-by-case basis. It's fact specific, but HUD regulations do have some guidelines for how we're going to determine whether there's an actual and imminent threat. But generally, you know, we need to see that there is a real risk of danger that's going to happen pretty immediately. Okay. And so some of the factors we're considering is the duration of the risk, the nature and severity of the potential harm, the likelihood that the harm will occur, and the length of time before the harm would occur. And they need to show that they can take no other action short of eviction before they can actually do that. Okay, so they do need to meet a high threshold before you can evict someone based on that kind of violence against the survivor. And when we say that the eviction must only occur if there's no other action to be taken, you know, let's talk a little bit about some of the other actions that a landlord can take short of eviction to protect the DV survivor, right? So first of all, the landlord can bifurcate or split a lease to evict the abuser while allowing the victim to stay. So basically that means both parties are on the lease. Generally you would have to evict all of them to get any of them out. And so we're saying, hey, in subsidized housing, if someone is a victim of domestic violence, then rather than evicting everyone because of the violence of one household member, we can go ahead and split the lease, make sure they're on different leases, and evict one person. And to evict that person, the landlord does still need to follow general eviction laws, but they can just evict the abuser. For like Section 8 programs, let's say, you know, survivor and abuser are, you know, living in Section 8 housing, and the abuser is actually the only one who is eligible to receive the housing assistance, and then this person has to go. Well, the survivor has a right to establish eligibility and see if they can, you know, take on the voucher themselves, or establish eligibility for another covered housing program, or they need to be given a reasonable time to move, you know, if they are not eligible. We can go to the next slide and talk a little bit about some other actions that the housing authority or landlord can take. Another thing they can do, let's say there are just multiple people in the voucher, the housing authority can terminate Section 8 assistance to the abuser only and preserve assistance to the survivor. Generally, in Section 8 housing program rules, you cannot just like move out of your property in violation of your lease, and you also cannot generally move during the first year of your lease, and generally you can't move more than once during a 12-month period. VAWA is going to create some exceptions for survivors of DV in subsidized housing. Okay, first of all, if a family needs to move out in violation of the lease, then for their safety, there's an exception for them to do that. And also, if you need to move for safety during the first year of your lease or multiple times in a year, you're going to be able to do that. So you can ask for like an emergency transfer to another unit if you're in project-based housing. And so there are you know, other options. there's a safety issue and the survivor needs to move. Okay. So we're gonna go to the next slide, and we do have a poll, and then maybe after the poll we can. I see that there's some questions in the chat, and we can take a look at those after our poll on the next slide.
Let me navigate to my polls again. 1 second. Nope. Let's see.
All right, so Tessa Tennant lives in subsidized housing in Antioch. On September 1st, she's attacked by her abusive partner in the front lobby. On the 3rd, her landlord serves her with an eviction notice for the altercation in the lobby. Can the landlord evict Tessa under these circumstances? Yes, he can evict her because the altercation is considered a lease violation. No, he cannot evict her for acts against her that constitute domestic violence. Or it depends on whether her housing is covered by VAWA. What do we think?
Give it a few more seconds. All right.
All right. Yeah. So, it's going to be no, he cannot evict her for acts against her that constitute domestic violence. I know we got a couple, it depends on whether her housing is covered by VAWA. That was a little bit of like a trick question answer there, because we do see in the first sentence that Tessa lives in subsidized housing. So we already know that her housing is covered by VAWA. So, and then even if she wasn't covered by VAWA, there's the question of whether he can evict, right? Because well, even though it isn't VAWA, if it wasn't VAWA, we might argue, is there some type of gender discrimination here? Is this still, something that the landlord can't do? Okay, and before we go to our next slide, I just want to see if any of these questions, what if the prospective tenant has a felony and was denied an apartment? I'm going to give you kind of an annoying answer. It depends. Basically, depending on the city, where they live, they might have some extra protections. Generally, like there are, like, for example, in Richmond, we have a fair chance ordinance. So there are rules against like blanket bans. And there was a state law that just passed that's against blanket bans. But so if you do have someone who has been denied an apartment due to some type of criminal record, please send them over to us to do the analysis to determine whether they have protections, because there are also just, various methods that we can use to get around policies like that, including, again, reasonable accommodations if the crime was at all related to their disabilities, things like that. Okay. And then Matthew, I'm not sure the answer to that question. I would need to look that up and get back to you. I'll take a note for myself. And then Melissa, I'm just going to say, if y'all have specific questions about clients, have them call our legal advice line, because that's going to be the best way we can get all the information we need to give them specific advice about what's going on with a tenant. But I will say, generally, if y'all have any clients who are experiencing domestic violence and need a partner, an abusive partner, or just an abuser rather, to leave, domestic violence restraining orders, if you are granted a restraining order, you can ask the court for a move out order. And if you can show the court that you have your own entitlement to the home, then they can order that the abusing partner move out of the home. Okay. Okay, so let's move forward.
Okay, thank you. So moving into the specifics of disability discrimination. Under the Fair Housing Act, it is against the law for a landlord or property manager to ask about a disability unless a tenant is requesting an accommodation which we will talk about in the next few slides in a lot of detail. Or if the tenant is applying for housing that gives priority to persons with disabilities. Additionally, the landlord or property manager is not allowed to discriminate in housing due to a person's disability, nor can they refuse to reasonably accommodate for disability. And nor that can they ask a tenant to provide more documentation that is necessary to verify a disability need for accommodation. It's also unlawful for them to ask a disabled person to prove the ability to live independently. And here we have some examples of intentional disability discrimination. So where the landlord or property manager, housing provider is steering the tenant to a certain building or floor based on their disability or the disability they perceive this person to have. So for example, saying, you don't want the unit by the pool because it's too noisy and you won't use the pool anyway. Or different terms or conditions or privileges of tenancy, such as requesting a higher deposit for a motorized wheelchair, but not requesting that higher deposit for manual wheelchairs or walkers or canes, or prohibitions like no wheelchairs in the lobby. So, as promised, here is additional details on requesting a reasonable accommodation. So, reasonable accommodation means asking for a change in a rule, a policy, a practice, or a service that is necessary to allow a person with a disability the equal opportunity to use and enjoy their dwelling. So here we're going to define disability as mental or physical impairment that substantially limits one or more life activities. And there is an asterisk there on substantially. So we'll get back to that. But substantially limits one or more life activities, and or there's a history of such impairment, and or the tenant is regarded as having such impairment. So the asterisk refers to that being a federal law, and under California law, they do not require the substantial limitation. It would just be a physical impairment that limits one or more life activities. So a slight difference there. All right, so how to request a reasonable accommodation. A reasonable accommodation may be requested verbally, but putting it in writing is preferable. A reasonable accommodation must also have a nexus to the disability requested. This means that the accommodation requested must be connected to the disability and be necessary for the person with the disability to use or enjoy their housing. Best practices: make the request in writing and provide verification from a knowledgeable professional if asked. That could be a doctor or a therapist if asked. That verification from the professional should include information that the impairment substantially limits or limits major life activity, and the need for the accommodation being requested. And when can an accommodation be denied? Under state and federal law, a housing provider must provide reasonable accommodations unless excuse me, unless the requested accommodation has no relationship to the person's disability, or if providing the requested accommodation would fundamentally change the nature of the provider's operations and would impose an undue financial or administrative burden or create a direct threat. So going back just a little, I wanted to give some examples about what the nexus between the disability and the requested accommodation could look like. So it would be challenging to prove a nexus between someone with a hearing impairment to request an assigned parking spot that is closer to their apartment. What is the connection between the hearing impairment and the need for the parking space, the closer parking space? On the other hand, a person with a mobility impairment that makes it difficult for them to walk is able to make a connection between the disability and the requested accommodation of a closer parking spot. If a housing provider believes that the requested accommodation is not reasonable, then the housing provider and the resident are supposed to engage in an interactive dialogue to get more information about the disability-related need and to find a reasonable alternative. So that's what this slide is addressing. Let's talk, the interactive dialogue. It may be considered discriminatory if a housing provider denies a reasonable accommodation and a resident housing provider denies a reasonable accommodation, the resident has the ability to seek enforcement of fair housing laws through HUD or the Department of Fair Employment and Housing. Although the request doesn't have to be in writing, we recommend it is, and the verbal request could trigger the responsibility under the Fair Housing Act. Verification of disability does not have to come from a doctor, and medical privacy rights are still protected by HIPAA, the Health Insurance Portability and Accountability Act. A failure for the landlord or property manager to respond to a request for reasonable accommodation is a denial. So here we're talking about reasonable modifications within the reasonable accommodation umbrella. So this would be a request for a change to the unit. So it must be requested by the tenant. And the difference here is that landlords in private property are not required to pay for the modification. If a tenant does not live in private housing, but lives in subsidized housing, then the tenant does not have to pay for modifications. And this could mean like a ramp or a grab bar in the shower. After the tenancy ends, if it's private housing, the tenant would be obligated to return the unit to the original condition at their own expense. But for HUD and subsidized housing, the tenant would not have that responsibility. So those are the differences there between private and subsidized housing and the reasonable modifications, physical alterations to the unit. Okay, so we have some hypos here. Are we doing the poll for this one too? Excellent. All right, so Requesting a reasonable accommodation. Someone with a mobility impairment can request a parking spot closer to their unit as a reasonable accommodation. True or false? Number 2, someone who has a hearing impairment can request a parking spot closer to their unit as a reasonable accommodation. And a person with a mental health impairment received a notice of a lease violation due to symptoms of his or her disability. This person can request the notice be withdrawn as a reasonable accommodation.
I'll give it a little longer this time since you technically have 3 questions to answer.
Thank you.
All right, slowing down. So I'm going to end it and share.
Okay, number 1, yes, true. The tenant with a mobility impairment can show the nexus between their disability and the reason they're requesting a parking spot that's closer to their unit. Number 2 is false, and it's similar to number 1, except that the tenant with the hearing impairment may have a tough time creating or showing the nexus between the disability and the need for a closer parking spot. And number 3 is true. A person with a mental health impairment received the notice of the lease violation, and they can request the notice to be withdrawn as a reasonable accommodation. And this happens a lot, and tenants who come to our clinics and are referred to us through our advice lines, they have UDs or even default judgments, and we have different motions that we are able to submit, as well as, in conjunction with the reasonable accommodation requests. So that third one is true. So other common examples of reasonable accommodations, I may have already mentioned these. Client needs a ramp to access an entryway of a home, the reasonable modification to install the ramp. Clients need an emotional support animal, but pets are not allowed in the unit. A reasonable accommodation to allow an emotional support animal. Client's source of income is SSI. SSI checks come in on the 6th of every month, but rent is late on the 5th. The reasonable accommodation could be to change the rent due date. And clients' disabilities make it difficult for them to move within the eviction period. Reasonable accommodation for more time to move. And I do want to be clear, we can't always make this, right with a reasonable accommodation after they've been served a UD or they have a lockout, but we certainly, do try. And how is fair housing enforced? It could be through an administrative complaint to the department, to HUD, Housing and Urban Development. It could be a complaint filed with the Department of Fair Employment and Housing, or a complaint filed with the Department of Justice. And it could be a defense in an unlawful detainer case, during the eviction process. Or it could look like a lawsuit, an affirmative lawsuit, where the tenant would be seeking money damages and injunctions.
So before we jump into this next section, I saw a question in the chat for you, Marisa. It says, so if the property doesn't allow tenants to use parking lots and they have to park on the street, even though all of the tenants in the building are disabled, is this legal? For example, if you have a heart issue and can't walk far already, you're living on the second floor, it's a long walk, and parking in the lot would be a much shorter walk. Do you want me to take that one or you got it?
Well, I'll just say it sounds like the tenant's not precluded from submitting a reasonable accommodation. What do you think, Maya?
Yeah, I think it depends. So when we talk about one of the times that a accommodation can be denied that Marisa talked about is if it would create a fundamental change in the business. So if they don't provide parking, like if there just is not parking for tenants, asking for a parking spot, might not be under the purview of the landlord. I think it would depend because it sounds like in this case there is a parking lot, and so I think depending on what that parking lot is used for, how big it is, like they could try and ask for an accommodation. But if no one at the property has parking, if that's just like totally not covered under their lease, then maybe not. But yeah, in a case where it's just gated off and there's a ton of free like just parking there, they could try asking for accommodation. It's just that it's going to depend. Some apartments are charging for parking. Is the cost covered under ADA if they're low income? Generally, if it's just private housing, then there aren't any real exceptions to having to pay for that parking. Obviously, apartment complexes are going to need to have ADA accessible parking spots, blue lines, but otherwise with parking, apartments can charge for parking. And but there is a new law that the parking cost needs to be unbundled from the lease, so they would need to sign a separate agreement for the parking. Okay, so let's quickly talk about these other tenant protections, and then we're going to get into a case study. I just wanted to cover two main ones that are going to come up pretty often. Obviously, source of income. So as of January 1st, 2020, landlords are required to accept Section 8 and VASH vouchers, other forms of rental assistance, and to consider them as part of an applicant's income. So if you're hearing landlords say no Section 8, if you're hearing landlords say, hey, we don't want anyone that's getting help from a program, that's going to be illegal, right? Like they cannot discriminate based on source of income. If you see that, send it over to us. We can help possibly, with like a letter or something to the landlord, letting them know their responsibilities to go ahead and process that application and, determine if the tenant is eligible under other their other criteria. Okay. And so there is nothing preventing the landlord from requiring the tenant meet other eligibility requirements, but otherwise they do need to rent Section 8 or other housing vouchers. Okay. So let's do one more poll if you want to go to the next slide. So Tina tenants looking for a place to rent. She finds a listing she's interested in, but the listing says no Section 8 vouchers. She also has poor credit. Regardless, she applied for the housing, but is denied when they learn she has a Section 8 voucher. Can the landlord deny her housing based on this reason? Yes, because source of income is not a federally protected status. Yes, the landlord can deny based on her poor credit. No, because source of income is a protected status in California. Okay. What do people think? All right. Yeah. So there's some interesting answers here, right? So, overall, what we're thinking with this question is here the wording's a little bit specific, right? So we're saying that they deny her when they learn she has a Section 8 voucher, right? We're letting you know she has poor credit, but that doesn't seem to factor into the landlord's decision making here. So, they're not going to be able to deny her based on that reason. But the fact that she has poor credit could play a role. Like they may be able to deny her based on that. However, there was a recent state law that just passed basically saying that if for subsidized housing, if someone, doesn't have credit or a rental history, you have to be able to give them a chance to show otherwise, like why they might be able to still be a successful tenant in this housing. Okay. But generally, yeah, landlord's not going to be able to just say, hey, no Section 8. Okay. And then I also just really wanted to kind of highlight some immigrant protections. So landlords cannot ask a tenant about their immigration status. They can't require them to make a statement about their immigration or citizenship status. And they also cannot disclose any information about a tenant's immigration or citizenship status for the purposes of harassment, intimidation, retaliation, trying to influence the tenant to leave, or trying to recover part of the dwelling. The one exception, obviously, to all of this is that some federal programs do require some citizenship eligibility requirements. So in that case, they're going to be able to ask, are you actually eligible for this federal funding? But otherwise, landlords are not going to be able to ask those kind of questions. Okay. So let's do one more poll on our next slide. Just a true or false. Tammy rents a studio from her landlord. She has a green card. During her tenancy, she needs several repairs. She's given written notice to her landlord. Landlord did not respond. After 3 weeks, the landlord states that she'll get a repair person out. No one comes, even after another reminder. Tammy calls code enforcement. Code enforcement investigates, orders the landlord to make repairs. Landlord's then pissed, and he accuses Tammy of being undocumented, tells her she needs to leave immediately, go back to her country, and sends her a text message threatening to contact ICE. What do we think? Does that sound like retaliation to us? So, true or false? Landlord engaged in unlawful retaliation. Yeah, true, right? So I know we have like an overwhelming 96%. This is kind of, one of our like red flag typos. Like he's been pretty clear. He's making it, very obvious. So it might not always show up like that. But just generally, keep an eye out because folks are entitled to their privacy around their immigration status, and the landlord cannot weaponize that against them in order to evict them. And so, sometimes we work with folks who don't have citizenship status who are afraid of complaining about repairs because who knows, the landlord might retaliate. And although, we can't promise that a landlord won't retaliate in violation of the law, we like to let folks know, like, it is illegal for your landlord to do this, and you do have rights. Okay. We're gonna do a case study now. Before we do, I know we've been going for like 90 minutes, thinking this might be a good time for like a little 5-minute bio break. And then maybe we can come back at 11:30. Does that sound good for folks? All right. So awesome. So just be back at 11:30. We're going to start right at 11:30. Thanks all. All right, do we want to get started with our case study?
Sure, I'm ready. All right, so this is a case study. It is a peek into the lives and housing related issues of tenants Tanya and Tevin. Tanya and Tevin met at college and have been dating for several years. Tevin is a veteran and a burgeoning writer. He recently published a book about his ancestral origins from Sierra Leone. Tanya is in grad school for a master's degree in botany. They recently were engaged to be married and decided to rent an apartment of their own. They began their search for a 2-bedroom, 1-bathroom apartment with the help of a housing navigator. The postings they find say things like, must be gainfully employed, or no Section 8, or only credit scores over 750, or single professional preferred, or must speak English. They are surprised by the advertisements and especially discouraged by the gainfully employed and credit score over 750 requirements. Based on their budget, they can afford $1,300 for rent, but all the 2-bedroom apartments were unaffordable at $1,500 and up. So we have the questions on the next slide. Maybe back one slide.
Do we have a poll for this, Shelby?
Oh,
Probably. One moment. Let's see.
so what protected classes or protected statuses or types of discrimination do you see or hear or think of? We're issue spotting here.
Only one of you has answered so far. It is a short answer question, so you do have to probably type. So I'll give you all a few more minutes.
If only one person has answered, it was me. So
Okay, then that doesn't count. Someone other than the
Yes.
trainer. Okay, we have a few more responses. We'll give it a couple more seconds. All right.
And I don't know about you, Marisa, but I can't see the answers. If you can see them, Shelby, do you mind reading them out?
Yeah, let me see. It took me to this weird other screen. Oh no. No, I can't. That was a fail for
Oh,
our
no.
poll. So maybe folks can see and say what they put. I'm sorry.
Yeah. Maybe folks can throw it in the chat what they put. Language.
Yes, language. No Section 8, yeah. Yes. Country of origin, ethnicity. Mm-hmm. Must speak English, single professional. Yes, all of these must be employed. Yes. So going through them, gainfully employed is a type of disparate impact, potentially affecting those who receive benefits and, get their livelihood from Social Security instead of, working a job where they get a paycheck every 2 weeks. The credit score, race, yes, I'm reading the answers as they come in. Another one is the Section 8, no Section 8, It's a source of income discrimination. So just because they have a Section 8 voucher, it's unlawful to discriminate against them because that's where some of their rent money would be coming from. The credit score, similar to the gainfully employed advertisement, where it creates a disparate impact on those who may not have had opportunity to build up credit, but can show that they would be able to pay the rent nonetheless in a different way. The single professional, that's grounded in the protected status of family status, marital status. And that would be intentional discrimination, saying only single people. And the must speak English. Yes, that is a national origin language. That would be a California protected status. And an intentional type of discrimination if they're just putting it out there. So yeah, great job spotting all of those protected classes and statuses. So the days of their lives passed, and their housing navigator speaks with Pamela, property manager, who says she has a 2-bedroom unit for $1,300 available right now. However, when the housing navigator tells Pamela that Tanya and Tevin are receiving rental assistance, Pamela says she doesn't rent to anyone getting help from a program. After some legal advocacy, Tanya and Tevin did go to see the apartment and moved in soon thereafter. Tanya applied and was approved for CalFresh food benefits to ease their tight budget. Pamela lived upstairs from them. She often made comments to them such as, "I've never had a Black man, let alone an African from Sierra Leone, living in this building. Plus, you two are not even married." Or, "Don't go having kids. Now, they're too noisy." Or, "You can't pay rent in CalFresh dollars." And, "Don't eat too much, Tanya. I know you have diabetes and I need you alive to pay rent." So what issues do you think are coming up here? What protected statuses?
Oh no, the same thing's going to happen. I'm going to end this poll. Same thing's going to happen. So feel free to put your answers in the chat because I won't be able to see people's responses.
Yes. Yeah, I'm seeing all these coming in. Race, ethnicity, racial discrimination, HIPAA, race, ethnicity, don't have any kids. Yeah, all of these. Pamela, property manager, is a real. All right, so going through these. The source of income, that she doesn't want to accept rent from anyone who is getting help from a program. So source of income discrimination grounded in the California protected status. And the racial comments about Tevin being from Sierra Leone. So racial discrimination, it was outright intentional. It's kind of a red herring because she's not evicting him for that, but I don't think it sounds in that racial discrimination area. And also in California's national origin, and California's ancestral discrimination. And the comment that they're not married, that if Pamela, property manager, were to try to evict them or something to that effect, then it could sound in the marital status, intentional discrimination under the marital status, California protection status. And then the don't go having kids, they're too noisy, family status. She's intentionally discriminating against them, telling them that kids are not welcome. And you can't pay rent in CalFresh dollars. That's another source of income, intentional. And this one about the don't eat too much, Tanya, you have diabetes. That was meant to trigger the medical condition genetics protected status under California law. So you all are really seeing the issues here. All right, and this is the second to last slide here about Tevin and Tanya. So they have settled into their new apartment. They're grateful to have their own space, even though Pamela lives upstairs and does not have good boundaries. They are also expecting their first child. When Pamela sees pregnant Tanya, she exclaims, "If you have a baby, your rent is going up." Twice, the rent has been late because they must pay rent in person at her property management office. On those two occasions, Tanya couldn't get all the way across town on the bus to the property management office before 2:30 p.m. when they closed. Also, Pamela, property manager, found out through the grapevine that Tevin is a veteran, and every time she runs into him, she questions him on his time as a soldier, asking if he saw anyone die or does he have bad flashbacks. So what potential protected statuses or type of discrimination do we see here? Veteran, familial, the child, yes. Mental health, yes, definitely. Family status, familial, yes. Yes, these are all protected statuses that are intentional discrimination. Yes, you all are definitely seeing the Easter eggs I've hidden. So, although Pamela hasn't acted on, let's say, giving them an eviction notice for any of these things, it is important, when we're talking with people to, listen to the things that they say. And oftentimes these times of, situations may be shared, like you wouldn't believe what the property manager says to me. So just to go through specifically, Pamela saying, if you have a baby, your rent is going up. So threatening to raise the rent because of a new baby or another person in the unit is definitely a violation of the family status under federal law protections and California. And it certainly seems like an intentional type of discrimination. And then the rule requiring that they pay rent way across town, that was meant to sound in the disparate impact type of discrimination. Here, we're not sure how Tanya hasn't asked for a reasonable accommodation to not have to go across town to pay, but it certainly is a hassle. So that was just a slight red herring, but everybody got it. It's the it's going out, it's something that's taking her out of her way and potentially having a disparate impact on her, on both of them. And then the rule against asking and probing questions regarding disability is also a slight red herring because Tevin did not request a reasonable accommodation or disclose his PTSD diagnosis to Pamela. So that's her being extremely up in their business. But again, they didn't request a reasonable accommodation. And then a rule requiring they pay rent. I already said that one. Yeah, so you spotted all the issues here. The veteran status as well. And now we're to the last slide. One day, Pamela confronted Tanya and Tevin on the stairway. She yelled at Tevin and Tanya, "I can't handle all this drama in my building. You're going to bring a crying baby into the apartment soon, and I'll never have any peace. I can evict you for that." The next day, Tanya and Tevin received a 3-day notice to quit based on breach of creating a nuisance. So the big question is, what can they do? So you can throw your thoughts in the chat, and the next slide goes into that as well. Yes, gotta be legal. Definitely. Call Bella. Yep.
Awesome. We can go to the next slide too. I love the call Bay legal, appeal it, call a lawyer, take the landlords to the housing clinic, file a claim for discrimination, right? So, what we're thinking is yes, send them over to legal aid for sure. And what we're going to do on our end is we're going to think about the different ways that fair housing can be enforced, right? So one thing they can do is if they're receiving a 3-day notice that they think is based on discrimination, they can file a complaint with HUD, or I'm sorry, I wrote DFEH, but it's, obviously we know it's CRD now. But they can file a complaint with the federal or state government, and that's just like a form online. They can go ahead, they'll send an investigator out, see what's going on, and then possibly intervene. Another way that we enforce the fair housing laws and the way we can protect this family here is that discrimination is an affirmative defense in an unlawful detainer. So if your landlord says, "Hey, I'm evicting you because whatever XYZ," you can put in your response, "I'm being evicted actually because of discrimination. Here's my evidence." And then, just a reminder again about a civil lawsuit. If they want to sue their landlord, that's not going to necessarily stop the eviction from happening, but it is another form of recourse for them. Okay. But that's why it's also going to be important that we look at this history of discrimination, right? We don't know what the 3-day notice exactly says. And maybe, you're talking to a client and it's not always clear within the last week that, there's been some discrimination that led to this, but clearly there's been a long history of discrimination with this landlord. Okay. So again, I just want to remind you all, so happy that everyone's like, call Bela, call Bela. That's great. And so I just wanted to throw this slide in here one more time to remind you how to reach us. Again, specifically, we're all in Contra Costa County. Just write down that number at the bottom, and definitely send folks to us, if they need legal assistance related to their housing issues. And if they have a non-housing issue, just send them to that top line instead. Okay. So we have about 10-ish minutes left. What questions do folks have for us, if any? And we will definitely stick around for a few minutes for questions. Someone's asking if they can see the last slide again. If you don't mind putting it back up, Shelby.
One moment.
And if folks don't have questions, it was great spending time together this morning into the afternoon. Great start to the
Don't
week.
leave yet because we have a survey at the end.
Oh,
and I know
yes,
Jamie will
okay.
want to get results. So let me put the
Yes.
number back up.
And then somebody's asking that we put it in the chat. Let me just grab it and copy and paste that for you. And the slides will be emailed, right, Shelby?
Correct. Yep. You probably won't get everything until next week. It's a whole rigmarole to try and get it out to you all. So I'm just going to let Jamie do that, but you will get them next week. And then I'm going to stop sharing. Thanks, Maya. Let me get the link to the survey so you all can take that. Doesn't have to be right this second, but I'll get it for you and put it in the chat.
Looks like we have a question about mold remediation processes.
Melissa, do you think you can expand on your question?
Yeah, yes, can you hear me? Can you hear me?
Yes, we can hear you.
Okay. Yeah, I have a question about Section 8 and mold remediation policies and timelines, and also where to go to find out if they've been discriminated, not discriminated, but just their rights have been violated. Took 3 months. They were pulled out of their apartment, they were put back in, then they were pulled out again, then they were put in a separate apartment, then they were locked out of that apartment. And then after 3 months, they finally went back in their apartment. And it just, but the 3 months, it was just horrifying and traumatic for them and just re-traumatized them again. So what can be done about that? Or is there a policy guideline?
Yeah, this is a little bit outside the scope of our training today, but I will say generally that folks have a right to something called the implied warranty of habitability in California, and there are some statutes requiring that landlords keep the property up to code. And so essentially, tenant does have a right to live in habitable housing, which means like, quick and immediate repairs, and possibly it seems like they've been moved to other housing, things like that, but they may have some rights to like recoup money from their landlord for overpayment of rent during this time that they're dealing with a mold issue. There's like potential to break lease and everything, but all of this, I'm speaking generally about mold. For the particular client that you're working with, it's really going to be fact specific depending on what's going on and what the household looks like. So I would just encourage that for this particular person, have them reach out to the tenants rights line so we can talk to them and see. But in general, just know, folks, that tenants do have a right to live in habitable housing, and landlords do need to remediate those issues as soon as possible. Mold is a little bit more complicated. It's not explicitly codified in the statutes, but obviously mold can cause health issues. And if we're seeing that, we definitely want to intervene as soon as possible. Paula asks, is a private landlord required to provide translation to potential tenants coming to check out their apartment or house if there's limited English spoken? I don't know that they need to provide translation just like for a visit, but they do need to provide a lease in the language that the tenant speaks. What's considered uninhabitable? There is a statute that I am going to copy and paste the language here so you can see what the specific language is. But for example, heating, plumbing, wall waterproofing. These are examples of things that absolutely need to be provided and in good order. Electricity, sanitation, no pests, no, rats and things like that. Here, I'm going to drop a link to the legislative code, and it has an explicit list of what is keeping it up to code, essentially.
Secure windows, doors that lock.
Marisa, do you want to take this question? What about a spider infestation?
Spiders, my favorite. Spider infestation would fall under a decreased habitability, meaning that it's part of what a tenant pays rent for is to not have spiders in their unit. So that's something the landlord would have to fix. It's on them to hire a professional to come out and eradicate the spider infestation. And if the tenant lives in a jurisdiction where they're under rent control, They could, same thing with roaches, yes. Slugs, rats, mice, all that stuff. Same thing, infestations. If the tenant lives in a rent control jurisdiction, they could go to the rent board and request that their rent be reduced for the time that they've had to live with the infestation. And if they are unsuccessful with getting their landlord to fix that, the decrease in rent may be both back in time for the time that they've already suffered with the infestation, but potentially into the future as well. So the rent control ordinances in local jurisdictions can be very helpful as well.
Aaron asks, can a landlord require the tenant take responsibility for pest and rodent control? This is the landlord's responsibility. The only time at which the responsibility can shift to the tenant for a habitability issue is if the tenant caused the habitability issue. So if tenant is refusing to take the trash out, just leaving it in their home and they get roaches, the landlord's going to be able to argue, hey, you caused this and therefore I don't have to take care of it. But otherwise, the landlord does need to take care of it. And you cannot waive habitability, right? So even if you go for a tour and you see that oh, there's no heating, that doesn't matter. The landlord still has an obligation to fix the heating. All right. Well, if there are no more questions, please make sure you fill out that survey. We love your feedback. Oh wait, we do have one more question. So yeah, heat is required.
And it's an essential service, so it is not legal to not have a heater, even in an SRO.